Thank you.
That should be fine.
Thank you very much.
Okay, I'll turn the live streaming on. Yeah, as you can see, it's now on.
Yeah.
We're just testing.
Could I just check that same permission we've got?
Yes.
Well, someone else who's attending remotely, that we're going to keep a phone.
As long as it's on silent. That should be fine. Do you want me to leave this on or not? I'll leave it on.
Yeah.
I don't want you suddenly, if they want to hear from you, then but I'll just close the two.
And they've all received the second supplementary.
Jeremy, you don't. I don't think your team oppose our application to rely on the Leeds and UCLH Cqc reports, do you? No. No. Yeah. That's agreed. And Paul, you don't either. There's nothing to be dealt with.
The bundle already.
They're in the second supplementary bundle.
Second supplementary. Oh, that's the one that was filed yesterday.
Yeah.
Yeah.
I don't actually have it. Does anybody have a hard copy of that?
I've got one. We have one.
You have one?
I don't have one. Oh, well, that's right. If you had one, I'd like one.
Well, I have my own, but I can sacrifice it for you.
No. No, keep on.
My solicitor has a second, if you don't know.
Are you able to,
Don't have
just in
one.
case it's referred to at any point?
Yeah,
Got it on my
it's
machine.
just all the
I'm not very
orders.
good at it. Oh, that's really kind. Thanks very much.
I think it's going to be a hot day today, so it might get a little warm in here, but the windows are open.
Thank you.
That's the
very
best we can do, I think.
much. Oh, marvellous. Okay. That one at the back, does that open anymore?
No, they're limited.
Oh, I understand.
But if you do feel uncomfortable, then I suppose you could ask the judges to perhaps derobe or something, you know, if you find it's unbearable.
We'll see how we go.
Absolutely. just okay, the judges will come back to their chambers. I've got your number. Fix with me. And then you'll tell me the clerk.
Yeah.
Live stream is on. Okay, we're going to put it on early. Okay.
Right, so thanks. There's a bundle on this thing. Yeah, okay.
Council, are you on ready?
Sorry, could you do me a favour and just this is over in the corner?
Okay, is that your one on the chair?
Yeah, it is. Lovely, thank you. I don't know. I just looked. Everybody loves it.
At the end of the week, I've got the computer here. I'll
Right.
send an email.
All right, don't worry. Well, I've been watching it. It's being streamed, isn't it? I've been watching
I'll
it, don't
just
I?
phone the chief justice's secretary.
Yeah.
No, I'll just. I don't know.
Yep, right, I'll look.
Oh, they have. Yeah,
Yeah, sure.
Scotland.
Hello.
Thank you very much.
Okay. Okay, all right. Yes. Okay, fine. That's fine. We'll be watching on the live stream anyway. You'll see.
Eh?
Can you see that?
Yeah. Or I'll see who's there.
Well, I'll stand.
Court is ready when
Okay, fine.
All rise.
Application appeal in the matter of between on behalf of Bell and another and the Tavistock and Portman NHS.
Yes, Miss Morris.
Good morning, Jane. Hello. I appear on behalf of the appellant, with Ms. Pond. The respondents are represented by Mr. Hine, QC, with Mr. Henson and Mr. Griffin. The first and second interveners are represented by Mr. Kendrick, QC. And the third intervener is represented by Mr. Skinner and Mr. Woods. There are also a number of other interveners, and you'll have seen their submissions in writing.
Certainly.
Well, also, my lady, we hope that you will have received what's called a second supplementary bundle yesterday. That largely comprises orders that have been made. In terms of housekeeping, it's my understanding that there are perhaps two matters still to be sorted out. One is our application to rely on a skeleton argument that was slightly over length, together with a supplementary bundle that was slightly over length.
Yes, well, 3 pages over, I would have thought with a little bit of editing it might have come down, but we've read it, and I would be surprised if anyone is going to go into bat over 3 pages.
Certainly, I think our perception is the respondents transgressed to a similar extent.
Yes,
so
well,
we all apologise.
let's not worry about those. Let's get to the substance.
The next thing is that my learned friend, Mr. McKendrick, has made an application for admission of the Cqc reports in relation to the trusts that he represents. It's a matter for you whether you wish to deal with it now or later.
Well, I think we'll hear such submissions are made on the substance of them, and we will consider the matter and around.
Certainly, I'm grateful. Well, the appellant is the Tavistock and Portman NHS Foundation Trust. It's an NHS trust that provides child and adolescent health services. Within that wider service, there is a gender identity disorder service, GIDS. That service has been commissioned by NHS England to meet a need that NHS England identified pursuant to its statutory obligations. Now, just for your note, those statutory obligations are set out in our skeleton below, and it's in the core bundle, page 590, paragraph 22. What is provided by my client's GIDS service is determined by that service specification drawn up by NHS England. Now, acting in fulfilment of the service specification, and after careful assessment over time, a small minority of the children who are admitted to my client's service, if it's considered appropriate, and they, their parents, and the professionals caring from them all understand the treatment and agree, are then referred to University College London Hospitals NHS Foundation Trust, or the Leeds Teaching Hospitals NHS Trust, the first two interveners, for further assessment and consideration of GnRHA treatment. Now, that treatment has come colloquially to be known as puberty blockers, and that's the language that was used by the court below. Now, it's this policy and practice, so described by the respondents, of referral from the service provided by those whom I instructed, the services provided by those whom Mr. McKendrick represents, which is the subject matter of litigation. Now, the respondents today are Ms. Bell, and she is a person who was a client of the service, and she started PB treatment over 16 years old. And the other respondent is Mrs. A, who has, she says, a daughter on the waiting list for treatment. Now, just returning briefly to that large number of written interventions, you will have seen that one of them includes the Endocrine Society. Now, that is a body which produced some of the international clinical guidelines upon which the service specification and in turn the clinical practice of the Tavistock and the hospitals elsewhere provide the service. And just to tidy up a loose end in relation to the nature of the Endocrine Society, it's a very large international organisation, and again, just for your note, you can see that in the further supplemental bundle, pages 57 to 58. Now, you should have had a timetable of speeches, and I'm probably optimistic that certainly I'll be able to keep to that.
Yeah, so you're going to be making submissions till 3 o'clock this afternoon.
Yes. What I propose to do is to order my submissions in the following fashion. First of all, make some introductory remarks concerning the procedural history and the subject matter of the litigation, and then turn to NHS England's service specification, some of the evidence, particularly that which isn't set out in the judgment below, and also address the up-to-date position in light of the decision in AB and subsequent actions taken by NHS England, so you can understand what the position on the ground now is. Then I'm going to turn to the law. Central to that will be the legislation and the decision of the House of Lords and Gillett, and then hopefully, having put those planks in place, I can turn to the grounds reasonably efficiently. Then starting with one or two elements of the procedural history. The original claim for judicial review was advanced on two bases. And again, for your note, they're set out at paragraph 14 of our main skeleton, and you'll find that in the core bundle at page 16.
So which paragraph of the skeleton, man?
Paragraph 14 of our skeleton, my lord. It might be convenient to say it's page 16 of the core bundle. So I apologise, the skeleton stops at 16, and then paragraph 14 is at page 22.
Yes.
So there were two propositions advanced. First of all, that children under 16 and young people under 18 could not, as a matter of principle, be competent or capable to give consent to the administration of puberty blockers. And the second was that the information provided to children and young people by the appellant in order to give the requisite consent was inadequate for the purpose of achieving informed consent. Now, the second of those failed completely. And then the first proposition also did not succeed in those terms. But what the court did was go on to make the declaration that is the subject of this appeal, accompanied by guidance in relation to both the under 16s and those in the 16 to 17 age bracket. And it's that which is the subject of the appeal.
Well, the appeal is against the order of the
Yes.
Divisional Court, which was the declaration reflecting paragraph 138.
Precisely.
At some stage, it would help us, I suspect, to have submissions on what the legal standing of the various bits of guidance that followed actually is.
My lord, yes, and of course we'll be very much helped, we submit, by looking at what was said in Y, and indeed relying on what my lord and my lady said in Briggs. But I'm going to obviously turn to that in due course. The other element of the procedural history that I would want to touch on at this stage, and it's the only other one, is the way in which the majority of the evidence relied upon by the respondents came before the court. Now, that set of pieces of evidence was submitted a week before their skeleton was due, and the propriety of its submission was addressed in various places, but again, in particular, in our skeleton below, which you have in the core bundle at page 585. Milady, do you wish to turn that up now? Oh. Milady, I'm
No,
giving
no.
you your note, but just to make it clear to everyone that
Right,
it
core-
was addressed in Core Bundle 585. So it was addressed, there was a set of submissions made in writing which you don't have in the bundle at an initial procedural stage, and then they were adverted to again in the written submissions. They were, the fact that they arose earlier is reflected in the order of Mr. Justice Lewis made on the 14th of September. I would ask you to turn that up. It's Core Bundle 653. So this is an order made in the run-up to the hearing by Mr. Justice Lewis. It's dated the 14th of September 2020. And if you turn to the second page at paragraph 4, he notes there that there's reference in the correspondence and submissions to whether other evidence in reply is expert evidence requiring the provision of the court pursuant to CPR 35. I make no ruling on that issue. There's been no application for permission under CPR 35, so there's been no application for permission on the part of the respondents. The court hearing the claim will, if necessary, and if it considers it appropriate to do so, rule on the issue concerning the claimant's evidence in reply. The point was raised orally at the hearing, but as far as one can discern, there was no express determination of whether or not that material should or should not be admitted. But obviously what we do know is that it is, parts of it are repeated in the judgment.
Was there ever, in fact, a formal application to admit it?
No. Turning now then to the subject matter of the appeal, which, as my Lord has said, is the declaration. We have that at page 70 of the core bundle. And that provides, it is declared that the relevant information that a child under the age of 16 would have to understand, retain, and weigh up in order to have competence to consent to the administration of puberty blocking drugs is that set out in paragraph 138 of the judgment, handed down in this case on the 1st of December 2020. And then I'll just briefly also ask you to note that at page 71, the court then stayed implementation of the order. And of course that stay was ultimately continued by the Court of Appeal upon an appeal. Now again, just to take a moment to look at what was provided for in paragraph 138 within the judgment, if you please turn to in the core bundle, page 107. So on page 107, about 2/3 of the way down, paragraph 138, the court says this: it follows that to achieve Gillick competence, the child or young person would have to understand not simply the implications of taking PBs, but those of progressing to cross-sex hormones. That's a core part of the reasoning. The relevant information, therefore, that a child would have to understand, retain and weigh up. So phraseology, which the lady and my lords will be familiar with from the Mental Capacity Act concerned with adults, in order to have the requisite competence in relation to PBs would be as follows. 1, the immediate consequences of the treatment in physical and psychological terms. 2, the fact that the vast majority of patients taking PBs go on to, now that acronym stands for cross-sex hormones, and it was explained to the court that that was a second stage of treatment, and I'll take you to the evidence in relation to that in due course. So continuing with the sentence, and therefore that she is on a pathway to much greater medical interventions. 3, the relationship between taking cross-sex hormones and subsequent surgery, and again, you'll see from the evidence in due course that surgery is only a possibility post-18, with the implications of such surgery. 4, the fact that cross-sex hormones may well lead to a loss of fertility. 5, the impact of cross-sex hormones on sexual function. 6, the impact of taking this step on this treatment pathway may have on future and lifelong relationships. 7, the unknown physical consequences of taking PBs. And 8, the fact that the evidence base for this treatment is as yet highly uncertain. And so those were the things which it was said a child would have to understand. Now, my lord, I'm obviously sensitive to what you've already said about the fact that what else was said was described as guidance. But I wonder, given that we do know that it has had already a very significant effect on the minds, certainly of GPs and possibly other clinicians, I wonder if I can just take the court to that material at this stage. So the other pieces of guidance are as follows. If you turn on, please, to paragraph 145 in the judgment. It's the second sentence. However, for the reasons that we have set out above, we think that it is appropriate in this case to give clear guidance as to the application of the Gillick test and treatment of cohorts of children. The conclusion we have reached is that it is highly unlikely that a child aged 13 or under would ever be Gillick competent to give consent to being treated with PBs. In respect of children aged 14 and 15, we are also very doubtful that a child of this age could understand the long-term risks and consequences of treatment in such a way as to have sufficient understanding to give consent. And then, if you have a look again, then at page paragraph 151. About halfway down, it says this: there will be enormous difficulties in a child under 16 understanding and weighing up this information and deciding whether to consent to the use of puberty-blocking medication. It is highly unlikely that a child aged 13 or under will be competent to give consent to the administration of puberty blockers. It is doubtful that a child aged 14 or 15 could understand and weigh the long-term risks and consequences of the administration of puberty blockers. And then if you would turn back to 147, it says this, with another however. We do, however, recognise that in the light of the evidence that has emerged, consider that phrase in due course, and the terms of this judgment, clinicians may well consider that it is not appropriate to move to treatment, such as PBs or CSH, without the involvement of the court. We consider...
If I could just ask you to pause there, that sentence I've certainly read as applying to all children.
Everyone under 18.
Yes.
Certainly that's why I've split these up in the way that I have, because certainly our reading is that 147 and 152 relate to children who fall within the Family Law Reform Act. And so, my lord, yes, continuing with that paragraph, we consider that it would be appropriate for clinicians to involve the court in any case where there may be doubt as to whether the long-term best interests of a 16 or 17-year-old will be served by the clinical interventions at issue in this case.
Sorry, Ms. Morris, you just said to the Lord Chief Justice that 147 and 152 apply with the Family Law Reform Act. I think my Lord was saying that his understanding of 147 that it isn't just a reference to 16 and above, but also a reference to 16 and below.
Absolutely, my lady. Sorry, I apologise. That I agree. It's what's particularly material for us, though, is the fact that it reaches beyond the under 16s
Understood.
to the over 16s, but certainly the under 16s are included within the class.
So even though the paragraph specifies 16 and 17-year-olds, it has application to children and young people.
Exactly, my lady. Thank you. I apologise for that. And then if you turn on to 152. So this is where it's more precisely put. In respect of young persons aged 16 and over, the legal position is that there is a presumption that they have the ability to consent to medical treatment. Given the long-term consequences of the clinical interventions at issue in this case, and given that the treatment is as yet innovative and experimental, we recognise that clinicians may well regard these as cases where the authorisation of the court should be sought prior to commencing the clinical treatment. My lords, my lady, we appeal on 8 grounds, and they're itemised in our skeleton in the core bundle at page 21 of paragraph 10. If I can briefly identify them and say how I propose to group them. Ground 1 is that the court wrongly departed from or restricted the application of the Gillick test. Ground 2 is that the court wrongly imported the law of the Mental Capacity Act into the Gillick test. And ground 3 is that what was said in the material which I've just read was incompatible with the provisions of the Family Law Reform Act. So that's perhaps one grouping. The second grouping is of grounds 4 to 7. And in essence, we say that the court erred in its approach to the evidence, and then, in consequence of that, made erroneous factual findings. And we identify, in terms of the errors in its approach, it wrongly relied upon expert evidence which should not have been admitted. If we're wrong about that, and it was entitled to admit that evidence, it wrongly purported to resolve issues of conflicting expert evidence.
Can I just put another marker down for everyone to consider? This is a claim for judicial review, and it's well established that if there is conflicting written evidence in judicial review proceedings, the court proceeds on the basis of the evidence of the respondent, for the very straightforward reason that it is not possible to resolve the conflicts, and there are exceptions to that, which you'll be very familiar with, and it doesn't appear from the papers we have that there was any real discussion about that below.
My lord, no. You'll see that we said what we said about the propriety of admitting the evidence, and we also did say in our skeleton below, and I can look up the paragraph over the short adjournment, that it is wrong for the court to engage in resolution of such disputes of expert evidence. And we also particularly pointed to the court the existence of the CAS review, which is the body which had been set up to review all the expert evidence on this area of treatment. And so we were able to say to the court, first of all, it's not a task which is apt for you, but also it's being done by an expert body commissioned by NHS England to make sure that any necessary consideration is being done by the appropriate individuals in the right way. Because of course, we simply don't have the tools to do that type of work. And so those two errors in their approach to the evidence, we say, led them to two particularly key errors. One is to find that the use of puberty blockers for gender dysphoria was experimental, and it was that experimental character of the treatment which justified its being treated exceptionally from both the Family Law Reform Act and Gillick. And secondly, that there was a causal connection between treatment with puberty blockers and proceeding to treatment with cross-sex hormones, although that was entirely contrary to the evidence advanced by the respondents. Indeed, both propositions were contrary to their evidence, and indeed that which is contained within NHS England's service specification. The final ground, my lords and my lady, relates to the Human Rights Act. You'll see that we touch upon that very briefly, and we understand that we don't have a victim status, but of course we would say that the court was bound by its provisions, but we don't pursue it with any vigour, but it's allowed other bodies such as the Association for Lawyers for Children to make submissions to the court. But I don't propose myself to detain you with beyond very much that's contained within the written documents. So the starting point is this service specification. And NHS England, in fulfilment of its statutory obligations, has laid down a very detailed and extensive service specification. And it's within the core bundle at page 484. It is a lengthy document, and I propose to take you to core elements because of its fundamental nature and because it wasn't addressed at any great length in the judgment below. So it's to ensure that my lords and my lady have some core propositions from it.
But it was before the court.
It was before the court, but you can see the extent to which it was addressed in the judgment. And so you can see how it's headed up on the top left. There's then a heading halfway down the page, population needs, and then a heading, national, local context and evidence base. And in due course I'll show you the detailed citations under heading evidence base at its conclusion. But just briefly, for our purposes now, the second paragraph down is the service is commissioned to provide specialist assessment.
I'm so sorry, which page are you on?
484, my lord, I do apologise. Core bundle 484.
Yes. So about the... Oh, I see, yes. I was looking for a heading. My fault.
It's probably mine. But anyway, so the service is commissioned to provide specialist assessment, consultation and care for children and young people, including psychological support and physical treatment. So physical treatments include puberty blockers, to help reduce the distressing feelings of a mismatch between their natal assigned sex and their gender identity. The service will also provide support to the family or carers of clients. It's worth noting the final paragraph on that page. The service will recognise a wide diversity in sexual and gender identities. So there's right on page 1 no ideological or other commitment to there being a monolithic form of gender or sexual identity. There's a commitment to the fact that there's a huge range. The next page is worth bearing in mind. Right at the top where there's a series of bullet points. The service will be delivered in line with emerging evidence for best practice, and we say that that would incorporate, for example, what's going on with the CAS review. Relevant national and international guidelines for the care of children and adolescents with gender dysphoria, such as and the World Professional Association for Transstandard Health Standards of Care. So we call those the WPATH standards because it takes some time.
And is that document at tab 1?
Exactly, and I'll take the court to that in a moment. So those are the international guidelines from the WPATH, and they're also international guidelines from the Endocrine Society, who I managed a moment ago. Also, the service is in line with the NICE guidelines more general guidelines in relation to the treatment of mental and emotional health and well-being, including for psychosis, anxiety, and depression. So it's within specialist guidelines concerned with this area and wider guidelines that exist across the NHS. And then if you turn on, please, to page 490, there is then a heading about a third of the way down, physical treatments. And obviously this refers to the treatments with which this litigation is concerned. And I'll just draw your attention to a few points. First of all, it's noted that the research evidence around the long-term impacts of some treatments is limited and still developing, and that by no means all clients with gender dysphoria choose to have physical intervention. So there's an express acknowledgement of the status of the evidence, and also that not everyone, and indeed I'll take you to the numbers in due course, but it's around 16% of those in a particular year that were referred to the service were referred on to the endocrine services, and of course not necessarily all of those, having then been further assessed and considered them, would proceed. So it's a small group of an already relatively modest group of individuals. What it does do, though, is go on to note further down the page that national and international guidelines, and they've just referred to them, do recommend the use of puberty blockers. And you see that in the second paragraph. And then, carrying on in the second paragraph, for some individuals, this is followed later with cross-sex hormones, and the division between those two treatments is followed later. Then it deals with the age of treatment in the penultimate paragraph. There's been debate about the minimum age at which puberty suppression and cross-sex hormone treatment could start. But the key point is this, in the penultimate sentence. Boys and girls enter puberty at different stages. And you'll see in due course that the criterion for a possible referral is TANA stage 2 of puberty. So the criterion referral isn't an age-based criterion, it's a developmental criterion. And then at the bottom of the page, in adolescents with gender dysphoria, psychological support and puberty suppression, so the use of puberty blockers, have both been shown to be associated with an improved global psychosocial functioning. Both interventions may be considered effective in the clinical care of psychosocial functioning difficulties in adolescents with GB, and then the citation. Then if you turn on to the next page, 491, the first full paragraph, in the Dutch long-term evaluation study, it's been found that the psychological functioning of selected transgender adolescents tends to improve after a staged program of puberty suppression, cross-sex hormones, and gender reassignment surgery. So that's a long-term study looking at someone starting with assessment and treatment in adolescence and concluding at adulthood. So that long-term progression has been demonstrated to be positive. And then if you look 5 sentences up from the bottom of that paragraph, no adolescent withdrew from puberty suppression, and then their psychological functioning improved steadily over time, resulting in rates of clinical problems that were indistinguishable from the general population. And then again,
it's relevant, isn't it? No adolescent withdrew from puberty suppression and all started cross-sex.
Yes. Then the last 2 paragraphs on that page, it says safety concerns remain regarding the impact of physical interventions. But then the next paragraph, the clinical team in Holland and the WPATH emphasise the importance of informed consent at each stage. This means that clients need to be informed about the possibilities and limitations of gender-affirming interventions and other types of treatment, including psychological interventions. As gender dysphoria may exist in many forms and intensities, gender-affirming surgeries are not the only treatment option, and the broader impact of gender-affirming medical treatments on many aspects of their lives has to be discussed, including fertility. And of course, you'll recall, as I explained a few moments ago, the criticisms that were made of the service provided by the Tavistock in relation to the provision of information in order to obtain consent were all rejected. And that all of these types of concern, indeed any other, were properly addressed. Now, the next relevant part of the service specification is on page 492. There's a heading Outcomes, and then it's matched with a set of domains. And domain 1, preventing people from dying prematurely. Experiencing gender dysphoria can be associated with acute distress. The service will seek to reduce the distress of clients by providing high-quality psychological and medical support, including physical interventions, as required on an individual basis. Then domain 3, helping people to recover from ill health or injury, and it identifies the morbidity that can be reduced by high-quality psychological and medical support, again, through individualised healthcare pathways. And then at the bottom of the page, referrals be made to the Pediatric Endocrine Liaison service when indicated. And then those consultants are the lead professionals for physical care. And then on the next page, 493, a heading in bold, as a result of interaction with the service, clients will experience a reduction in the level of distress and conflict around their gender dysphoria and have an increased ability to function well in daily life in relation to their gender identification. The next page I'd ask you to look at is 495. There's a heading there, Objectives. Third paragraph down, again an emphasis on improve psychological health and social inclusion by delivering tailored treatment packages. And then the end of the next paragraph, ensure that clients have adequate time to fully assimilate the effects of each stage of physical intervention and the different options for gender expression, recognising the needs of each person will be different. And then at page 497, you can see the criterion that I referred to in relation to TANA stage 2. It's the third bullet point down on page 497, midway through the bullet point. There then follows some flowcharts at pages 500 and 501, where you can see that there is not one clinical pathway. There are a multitude of clinical pathways consistent with the repeated statements that the service will address individuals individually. And then at 502, there is a heading Service Inputs, and at the third bullet point down, one of the things which the Tavistock Clinic is to provide is referral, when appropriate for the needs of the client, to the Pediatric Endocrine Liaison Clinic. So that referral, which is the subject matter, what's attacked by the respondents, is something which the Tavistock Clinic is required to provide pursuant to the service specification, if in its view it will meet the needs of the client. Then at 504, there's a heading psychological support at the bottom of the page, and the last sentence is the service will take into account new guidelines and evidence as they are published. And then at page 507, at the bottom of the page, there's a heading informed consent. There's a repetition of this point of the recognition of a wide diversity in sexual and gender identities, and will affirm the importance of each person to develop autonomy in relation to treatment decisions, as well as need for support from their family and the professional team. And then there's a lengthy provision in relation to consent. And I draw your attention to the following elements. If you have a look at page 508, the second paragraph down, the service will support the client and their family or carers to jointly understand the factual information. So the work is family-based. Next paragraph, age alone does not determine capacity to give consent. So again, entirely consistent with what is said in Billick. And then in relation to assessment of capacity, then there's a correct statement of the law in relation to what competence is. Then there's a paragraph sort of halfway between the two hole punches which says that capacity and competence will be assessed, and then with special care for those under the age of 16. And then underneath that, all efforts will be made to ensure that clients are aware of the longer term consequences of the endocrine treatments, including implications for fertility, and the decision of competence will be made jointly by the endocrine and psychological. So you've got a multidisciplinary team making the decision. It's not just one person making the decision. And then there's a reference to a further appendix with a guidance on informed consent, and I'll take you to that in a moment. Page 509, at the bottom of the page, you can see that there is a clear distinction made between puberty blocking treatment and cross-sex hormones. They're described as two separate categories. And then if you turn over the page to 510, third paragraph down, hormone blockers will not necessarily be viewed as the precursor to the prescribing of cross-sex hormones. The next stage of treatment, if any, should be left open for further exploration for the client. So there's a clear break between one treatment and the next, with a whole process of reflection and assessment between the two. Then there's emphasis again on the multidisciplinary team, and then you can see under the heading staffing, 2/3 of the way down, those who are included within that team. And if you turn then on to page 513, there's a heading halfway down, criteria for referral to the Pediatric Endocrine Liaison team. And that essentially repeats very much the material to which I have already taken you. But you can see that the criteria are importantly emphasised that hormone blockers are not a precursor to prescribing of cross-sex hormones. It's going to be an issue which is literally left open. Decision is made by a multidisciplinary team. It's individualised. Competence is specifically assessed. A decision is going to be made after an in-depth discussion with the multidisciplinary team, and then the criteria of referral are set out going over the page for both age groups. And then if you turn on to page 515, about halfway down the page, once again, the service provider will make the young person and their family carers aware of the risks, contraindications, and any irreversible or partly reversible effects of any interventions. So absolutely everything is out on the table. And then if you turn on please to 521, there's a heading before about 3.5 pages of academic citations under the heading evidence base, and indeed you'll have seen through the text that there are notes that reflect this material. Then if you carry on to 527, this is within a section which provides a glossary. At the top of page 527, you've got GnRHA treatment, and at the end of that, you have yet again this statement that it's used by the service to halt puberty in order that the client can further explore their gender dysphoria without the fear of puberty progressing. And then if you would go on please to 541. This is the Appendix 7, to which I referred, and again, express reference to the WPATH guidance, and also materially here at 7.1.3, so about 2/3 of the halfway down. It's important for assessment to set out the possibilities and limitations of different treatments. It's necessary for informed consent, but also important for assessment. So it's not just a sort of tick box consent exercise, it's part of the wider dialogue which is provided by the service. So that's all I have to say about the service specification. I wonder if I can just briefly show you the two sets of international clinical guidelines on which the service specification and those whom I represent rely. They are contained within the core bundle. And again, these were before below. The WPATH guidelines are right at the start of the supplemental bundle at page 1. And the meat of the guideline starts at page 7. So, first paragraph, second line, they set out their mission, which is to promote evidence-based care, and then they say that they are dedicated to developing best practice. In the second paragraph, third line down, the standards of care are based on the best available science and expert professional consensus. Then if you turn on, please, to page 14, there's a heading, Advancements in the Knowledge and Treatment of Gender Dysphoria. And about 2/3 of the way through the first paragraph, they refer to satisfaction rates across studies range from 87% of male to female patients to 97% of female to male patients. And regrets were extremely rare. Then if you turn on, please, to page 16, there is a whole chapter on the assessment and treatment of children and adolescents with gender dysphoria. And within that, I just invite your attention extremely briefly to page 24. Where you can see in the first set of indentations a clear distinction between 3 stages of treatment. That by puberty blockers, which is described as fully reversible. Secondly, cross-sex hormones, which is described as partially reversible. And then thirdly, surgical procedures. And then at the bottom of that section, a staged process is recommended to keep options open through the first 2 stages. Moving from one to the other shouldn't occur until there's been adequate time to assimilate fully the effects of the earlier interventions. And then there's a heading, fully reversible interventions. Again, a reference to the fact that the criterion is Tanner stage 2. And it makes the point that some children may arrive at this stage at a very young age. And then if you go on to page 20, and then you can see the criteria.
Just before we go on there, in the second paragraph down at page 25, this talks about 2 girls justifying intervention. One is the time to explore, on which you heavily rely, but the second is that it may facilitate transition by preventing the development of sexual characteristics that are difficult or impossible to reverse.
Yes.
So it does seem to suggest that this document, which is incorporated into the service document, regards there being two uses of PVs, not just the one you've highlighted.
Well, Milady, the way in which the purpose is put in the service specification is to reduce distress, and having then reduced that distress, it creates the possibility of time to consider options without puberty progressing. And it's certainly accepted in the WPATH document that puberty not progressing may facilitate transition. So it's not anything required, it floats that possibility, Milady. The key points in our submission are those which are contained within the service specification, particularly within that glossary. And it's very important in our submission to understand the relationship between the reduction of distress and being provided with time to think. Because, of course, if puberty progresses without a pause, then the distress which is caused by the progress of puberty inhibits the thinking which will allow the child to make an informed choice about their future. And that's why it's so important. It allows the child to make a choice. Then if one proceeds within this material, please, to page 26, there's an acknowledgement, which again is reflected in our client's evidence, just before the second just before the second puncture hole. Although the very first results of this approach are promising, the long-term effects can only be determined when the earliest treated patients reach the appropriate age. So again, there's an acknowledgement that in any treatment that is embarked upon, one has to wait for that cohort to reach the end of their lives, effectively, to know the full impact.
But we have to, of course, read the whole of that paragraph against the context of you saying that this is wholly reversible, because it clearly says here you can't regard it as a neutral act.
Milady, certainly it isn't a neutral act, because not providing treatment means that the child remains in a position of distress and difficulty in making choices about what to do next.
No, but here what it's saying is that it's not a neutral act, because on the one hand there's the distress point that you highlight, but on the other hand there's concerns about negative physical side effects, bone density and height.
Milady, yes.
Which has to be put into your reversibility equation.
Yes, although the evidence that we have, and certainly will be addressed particularly by Professor Butler's evidence, is that when a puberty suppression ends, those matters are ultimately rectified. And so it is reversible. It's not that there is a permanent, for example, loss of bone density. It's also important, Milady, to see where something addresses puberty blockers followed by cross-sex hormones rather than simply puberty blockers.
Presumably the high incidence of the one following the other is reflected in the very proper referral throughout the three documents you're taking us to the importance of children understanding the impact of it on their long-term fertility at the PB stage.
Well, certainly, Milady, the position is that if one takes puberty blockers, that doesn't have any long-term, and indeed they're the drugs that are taken in fertility regimes. And so, of course, if they were to have such effects, no one would be taking them in that context. The question then is whether a child is counselled about fertility implications of the next stage, and you can see from the material to which I have just taken you, and the material of which was endorsed by the court, which is all of that is explained at the initial stage. And so you can see from going through the service specification, indeed you'll see from the evidence, that at the puberty blocking stage, it's explained that there might, or there are indeed, a range of options, but it's that emphasis on a range of options in the material to which it's taken my lady. There is no suggestion anywhere that this is a one pathway. You can see the flow charts, you can see the emphasis on individualised care, you can see the emphasis on the fact that there is a time to consolidate the effects of one treatment and to consider it, and then to make decisions in the light of all of that. And it's, of course, an elementary proposition of science and logic that constant conjunction is not causation. And in any event, there's no shying away in this process of explaining to children and young people what the possibilities are. And indeed, you can again see from the material that I've shown the court that their response to those possibilities is seen as diagnostic as well. Milady, I'd ask you then to turn on to page 113. And then there's a heading, Appendix D, Evidence for Clinical Outcomes of Therapeutic Approaches. And at the end of that, on 114, a reference to the very low numbers expressing regret. Then I'd ask you, please, to go on to the Endocrine Society.
Just give me a moment to catch up.
Oh, I'm so sorry.
It's all right.
Where is the reference to a low number expressing regret on 114?
It's in the last paragraph, about halfway through, my lord.
Fewer than 2% of patients expressed regret after therapy.
Yes.
So if you would turn on, please, to page 121. This is where the Endocrine Society's material starts. And it says, right on page 121, halfway down, this is an evidence-based guideline. And the task force commissioned 2 systematic reviews and used the best available evidence from other published systematic reviews and individual studies. And in the summary, at the top of page 122, 4 lines down, we recommend treating gender dysphoric, gender incongruent adolescents who have entered puberty at Tanner stage 2 by suppression with GnRHA treatment. So that's the summary of their position.
Sorry, I need to catch up. Where exactly is that? Which page?
So page 122.
Yes. Summary of recommendations.
Above that. I apologise. So there's sort of the headline, about 5 lines down. 4 or 5. We recommend treating gender dysphoric gender incongruent adolescents.
No. Oh. Okay.
So this is the abstract,
Yes.
effectively. Yes.
Thank you, my lord.
Very top of page 122.
Yeah, no, I've got it now. Thank you.
Now, then there's a heading summary of recommendations, and just briefly, if you turn over to 123 at paragraph 1.5, there is entirely consistently with what I've just said to my lady, the recommendation that there is counselling about fertility preservation before initiating puberty suppression and prior to treating with hormonal therapy of the affirmed gender, that's cross-sex hormones. So there's full acknowledgement of the extent of the advice that is to be given at the initial stage. And then if you turn on, please, to 132.
just before, sorry to interrupt again, but just before you go on to 132, there's a reference at, under remarks,
Which page, my lady?
131.
131.
Need for adequate information about the treatment in general, about fertility effects of hormone treatment in particular, to make the informed, because young adolescents may not feel qualified to make decisions about fertility and may not fully understand the potential effects of hormonal interventions. Consent and protocol education should include parents, the medical health practitioners and other members of the support group. And then it goes on, there's no formally evaluated decision aids to help in the discussion and decisions.
Yes, maybe there are no formally evaluated decision aids to assist in decision making, but what we do know is that the court below had no criticism of failings in decision making in this case, in the way, and you'll have seen the very detailed prescription in the service specification, and indeed in other documents before you, although I wasn't proposed to take these, you can see the standard operating procedure which is in place in terms of consent taking, and indeed I can show you the evidence there is about the sophistication. And indeed, Dr. Alvey, who is at the Leeds Trust, says she considers the consent taking to be an example of excellence within the NHS, because it is such a careful and lengthy and essentially repeated, a continual rechecking of understanding, and therefore it's actually some of the best, if not the best, consent taking in the NHS, and it's very far from what also my lady very familiar with it. You know, seeing a sort of quick form before you go into surgery and sort of saying yes, I understand. It's at the absolute other end of the scale.
I think really when I read this in advance, what struck me was tying it into the judgment as was given, that it was being reflected there that young adolescents may not feel qualified to make the fertility, may not fully understand the potential effects. That, in other words, they're not capable because of their level of maturity and understanding. And I'm just flagging up that potentially seems to tie in with some of the findings of the judges at the divisional court.
The lady, it's certainly true that there are some people who don't understand and perhaps won't understand. But that is not the issue. The problem is the way in which the court has dealt with the case by essentially making generalisations and drawing lines contrary to what the House of Lords said. And what is important is that just because some adolescents may struggle, there are equally those who won't struggle, particularly when they are assisted by this sophisticated process. And although, of course, there's an issue in this case about the extent to which one learns from the Mental Capacity Act, but of course, it's the legislation in relation to adult capacity specifically requires assistance to be given to enable a person to acquire capacity. And we say that principle should apply to children and young people in the same way. And so if, with explanation, support, rechecking, and so on, and the process, the complex and lengthy process which is adopted in this case, the court should allow for the possibility that with that provision, a person of any age might attain the relevant ability to make a decision. The other important point...
Well, I did, as I read the divisional court judgment, because ground one wasn't successful, it didn't say that youngsters under the age of 16 can't give valid consent. On the contrary, it accepted that they could.
Well, but only within this very hedged about language. The difficulty is, in one sense, the court avoided committing the sort of cardinal sin and saying they never can in the way that they were invited to. But what they did do was create what the third intervener has called a presumption, which wasn't previously there. And that, my lord, is perhaps one of the difficulties, particularly given the way in which it bites upon the mind of clinicians and the concerns that they might have. And there is another point, my lady, coming from this paragraph, which is the emphasis which is on the family. And my lady, you will have seen that a linchpin of the process of those whom I represent and those whom Mr. McKendrick represent is that this is a family decision. So whoever is providing the legal consent, it's nevertheless the case that it is the family who are joining in the process of learning, of understanding. And my lady, we say that's important. And it's interesting because if one looks at the tensions that arose in cases such as Gillett and Axon, that core tension is simply not there. And no one is suggesting that a family, parents, other carers should be told that you can't possibly understand this. There's another feature of the material, which is this, which is that, and I think it's reflected in the Endocrine Society material, and I cut the reference. One of the points that's made is there are certain aspects of the understanding of people, or children and adolescents with transmission, need to bear in mind they're not like sort of everybody else for two reasons. One is they're having a unique internal experience. So they're having the experience of gender dysphoria. And that's why perhaps this criterion of being at Tanner stage 2 is important, because they are already having that hormonal bath. They're already having those hormones in their body, having the effects on their brain, which we refer to. So they have a unique experience of having that hormonal experience, but experiencing themselves as trans.
But isn't one of the reasons for delay till Tanner 2 is the vast majority of children who are suffering from gender dysphoria, it resolves in early puberty.
That's certainly one of the issues. And the point is that waiting till Tanner stage 2 allows one to identify much more precisely, it's not the only method, but much more confidently and precisely those for whom puberty blockers are likely to be appropriate. But the other point, of course, is that within the family of a trans child, again, the family have another set of understandings as a result of being part of that family process, which perhaps not every other family has, because they're grappling with this issue and thinking about it. And that's why assessment of competence or capacity should be individualised because of each individual's unique experience. And that's why it's problematic to say, oh, well, what 12-year-old understands this, or what 15-year-old understands this, because, of course, every 12-year-old is different, and, of course, there are very special kinds of difference which impact on your competence or capacity. You know, if it's happening to you, you're going to be thinking about it. In a way, if it's not happening to you, there's no need to think about it.
I think you again show us 132.
Thank you. So at 132, under the heading Evidence, pubertal suppression can expand the diagnostic phase by a long period, giving the subject more time to explore options and to live in the experienced gender before making a decision to proceed with gender-affirming sex hormone treatments, some of which is irreversible. And so there's again, I take my lady's point that there's perhaps more than one reason, but again, there's emphasis on that core reason there in the clinical guidelines. And then if you go on, please, to 134, there's a recognition there. I'm concerned about time, and therefore I don't want to take too long with all the possible side effects. And so, again, there's no shying away from the fact that this is not a simple and perfect treatment, but it is nevertheless one which is recommended. And what it also notes there is that the evidence demonstrates an improvement of psychological functioning in several domains. So briefly, to take away from that, an acknowledgement that this isn't a simple and perfect treatment, but it is nevertheless one which is recommended by this august body on the evidence. Now, the other part of the framework is that there is an extensive regulatory scheme of healthcare provision in this country. And we've already touched on the fact that this service is only provided because it is commissioned by NHS England. And we can see from the service specification that it is specifically required to respond to evidence as it emerges. And we know that an analysis of the up-to-date evidence is being undertaken by the CAS review. And again, for your note, the terms of reference of a CAS review are set out in AB, and you've got that in your main authorities bundle at tab 14, and the terms of reference are at paragraph 105.
Sorry, we don't have tabs, you'll have to give us page numbers.
Oh, it's the last one.
Right.
Would that help? If I
Which
Definitely
page
no.
or paragraph in AB?
It's paragraph 105 in AB. I'm not sure it's necessary to look at it right now, but just so that you can see. I'm just trying to tell you if you want to see how extensive it is. Sorry? It's page 470 as well.
So that's first authorities bundle.
Yes. Now, we know that they have, since the last hearing, albeit it was undertaken before the last hearing, published their initial evidence review. And that is before you, pursuant to the order of my Lady Lady Justice King, in what's called the unagreed bundle. There's a sort of host of entertaining names for bundles. So I think cross out on, or anyway, it's
At least
there.
it's a small bundle.
Yes, exactly. It's always a
We
good
call
thing.
it the black bundle.
Oh, I don't have the same colours, I'm afraid. And I got into trouble once for describing bundles my colours in the public view. So it's there, and it's at page 95. And I just draw your attention to a few things, just to say, well, this is the sort of interim thinking of the CAS review in October 2020. So actually, quite a long time ago now, about 18 months ago, more than. But this is where they've got to. And you'll, I just ask you to note a few things. Page 97, third paragraph down, second sentence. The intention is to alleviate the distress associated with the development of secondary sex characteristics, thereby providing time for ongoing discussion and exploration of gender identity before deciding whether to take less reversible steps. Then at 98, there is an acknowledgement under a heading impact on mental health that the treatment may reduce depression. That's the first one. And then, but perhaps most importantly, if you have a look at the conclusion at 107 and the second paragraph, and this is what it acknowledges here, that even if there isn't a stark difference in outcomes before and after the use of simply puberty blockers, it is plausible that the lack of difference in scores from baseline to follow-up is the effect of GnRH analogues in children and adolescents with gender dysphoria, in whom the development of secondary sexual characteristics might be expected to be associated with an increased impact on gender dysphoria, depression, anxiety, anger, and distress over time without treatment. And then it refers to the DeFries study, and it says, as the aim of these analogues is to reduce distress caused by the development of secondary sexual characteristics, this may be an important finding. So what they're getting at is that looking at the progress of this cohort of children untreated is you expect their psychosocial difficulties to keep getting worse. Whereas if you treat them with puberty blockers, they essentially don't get worse in the way that is anticipated. So I understand a point may be made by the respondent saying, oh, well, look, people aren't magically better. But the point is, what is better in this context? And it's stopping people becoming more distressed and the morbidity that's associated with that. Then the next item in the back bundle, the unagreed bundle that I touch upon, is the Cqc report. And I'm not asking you to look at it, but I'm just going to say a couple of things about it. It's at page 226. There's another document which wasn't published at the time of the hearing. But what we say is important about it is that it demonstrates the efficacy of the regulatory framework. The CQC it has powers in relation to both NHS and private healthcare. And in this case, it went in, it made a lengthy inspection, it's made findings, some negative, and it is securing their being addressed. Now, of course, what I must advert to is the fact that Mr. McKendrick's clients have had very positive Cqc reports, and I'll allow you to address him on it. And of course, they're the ones who actually prescribe treatment. What my client is concerned with is referral to those services where the treatment may be prescribed.
With heavy criticism about consent.
Yes, although again, my lady, you'll see that that was historic, and between that historic criticism and today, there is a new standard operating procedure. But of course, the final consent that's taken is that which is taken by Mr. McKendrick's clients, and there's absolutely no criticism of their consent taking, my lady. And what's important to bear in mind is that when a patient is referred from those whom I represent to Mr. McKendrick's client services, a whole further process of discussion and consent taking takes place. So while we say that we have now put our house in order for the reasons that we've explained, even if one is looking at the historic position, one can have real confidence in the consent taking, which was that further process.
Well, you say historic, but their audit went up to September 2020, with the inspection in November, and the hearing was in December. So it's not current. I think historic is perhaps ambitious.
So, my lady, the next element of regulation that exists in this country is, of course, of individual professionals. And that's something which has been adverted to in many of these cases in this arena. So each professional doctor, psychologist, whoever, is fixed with a very extensive set of obligations. Of course, my Lord was concerned within the Bauer-Garber case. So we know that there is a great deal of law surrounding this process. You've got NHS England and its application of NICE. You've got the CQC, which governs the operation of institutions, and you've got the GMC, the HCPC, that regulates the individual. And so we'd say there's no shortage.
Sorry, the second acronym.
And that governs, for example, psychologists, HCPC, Health and Care Professions Council.
Thank you for reminding me.
That's all right. There are quite a few of them now. I mention it because, of course, for example, Dr. Carmichael, I think that will be her regulator.
Yep.
Now, my Lord, the next and hopefully penultimate bit of evidence or contextual material is just to draw the court's attention to the evidence of the treating clinicians. And so, as my Lord said, that evidence which would typically be relied upon by the administrative court in the case of judicial review where a clinical practice is being challenged. And you have this material within the supplementary bundle. And if you would turn first, please, to 156. So Dr. Carmichael is the director of the service, and she's a consultant clinical psychologist. And if I can draw your attention, please, to 4 paragraphs. Paragraph 41, which is at page 165. So she addresses there the proposition that children aren't able to do this, and she says, In my experience, those young people we see who are recommended for this treatment understand the implications and limitations of treatment and are able to consent to this stage. And then she deals there with the purpose, and she says it's hugely beneficial in alleviating distress and can allow the young person to consider more widely what they may want for themselves without the pressure of further changes to their bodies. And then 42, she deals with the clear distinction, and she uses at the end of 42, last sentence, the phrase, the two treatments are separate and distinct. And then at paragraph 47, she deals with a sentence in a report produced by the Health Research Authority in relation to some research being done, which had been relied upon by the respondents to suggest that there had been a statement that the practice was misleading rather than the research process. And then I'd ask you then to look at paragraph 50 at the bottom of 168. Again, this emphasis between the distinction between puberty blockers and cross-sex hormones. And I've shown you the clinical criteria in the service specification. Different criteria are to be fulfilled in relation to referral for cross-sex hormones as against puberty blockers. Now, the next piece of clinical evidence I'd ask you to look at is from Professor Gary Butler. And you have that a little bit further on in the bundle at 176. Now, my lords and my lady, Professor Butler's statements are admirably succinct and clear and address a number of potent issues. And so I would invite you to read his statement in full. Just for the purposes now, I'd ask you to note his qualifications and position at both UCLH and Great Ormond Street, and note that he's a fellow of the Royal College of Pediatrics and Child Health. I won't go through all his expertise. And I would draw your attention in particular to paragraph 9 on page 179. And he deals with the information which is provided, and then also he specifically deals with this question of whether puberty blockers are reversible. And it's 6 lines up from the bottom. He says, fully reversible from the reproductive perspective. There are multiple publications to this end. And then I draw your attention also to paragraph 18. This treatment is not, in itself, is not experimental as it's over 30 years old. Use in transgender young person is more recent, with initial studies having been produced on which a lot of the processes at the UCLH Joint Liaison Clinic have been based. But he explains that it's consistent with what is done in accordance with the guidance of the Joint Standing Committee on Medicines, and he refers to that paragraph 22. And he also says that the assessment of competence is in accordance with that which is carried out pursuant to the Academy of Medical Colleges, and that they say that an assessment of competence is best done by the treating doctor. And we've got that guidance at 262.
Sorry, just pausing there. Which paragraph were you reading from just now?
Sorry, so
It's
it's 18,
yes.
and there's a reference to the study. Have I got the incorrect one? And then paragraph 22 is where he deals with the Joint Standing Committee on Medicine. Oh no, am I looking at the wrong? I'm looking at the wrong one. I apologise.
Yes.
I've gone from one statement to the other. So I apologise. 15 you need to look at, where it's paragraph 15.181, where he deals with the W path, and at paragraph 16 he deals with the use of puberty blockers is well established in the field of precocious puberty with long-term outcomes, including on fertility. So he says that's it's known, and then at 17 he deals with the use of label. And where I've got confused is he produces a second statement, which we have at 245. Now the second statement, again very short and to the point, at paragraph 4 on 246, he makes clear the distinction between puberty blockers and cross-sex hormones, and he says young people who wish to continue to stage 2 treatment, so cross-sex hormones, and this is not by all means all those who have received puberty blockers, brackets, it's approximately over 80%, will have detailed discussions with the JIDS team at the Tavistock, overseen by their individual psychosocial clinical needs. And then if you turn on to paragraph 16, he makes another statement about the reversibility of puberty blockers and makes the point which I made to you a few moments ago. This is used in fertility treatment regimes. And then reference to consistency with the statement from the Academy of Medical Law Colleges as to the assessment of competence. And then at paragraph 2, the use of such medicines off-label being consistent with the Joint Standing Committee on Medicines, which is a committee of the Royal College of Pediatrics and Child Health. And then he exhibits to his statement one of his academic papers on the topic. You have that at 256. And within that, he makes a particular statement at page 260, top left, psychological benefits of puberty blockers.
Is the evidence for the reversibility purely obtained from precocious puberty trials, or is it obtained also from those who take puberty blockers and then come off them without proceeding to CSH treatment?
My lord, yes, and it's not as confined as that, and indeed I'm going to take you to the witness stand of Dr. Albee, who says it's used in other contexts as well. So, but we know it's used in fertility treatment. It's used in precocious puberty. Dr. Albee explains that it might be used, for example, with children with learning difficulties, and we have that at 279. And so she says this, paragraph 31, 279. These analogues are well-established hormone treatments used in adult medicine for endometriosis and prostate cancer and for the treatment of infertility. Their use is in central precocious puberty is well known, but paediatric endocrinologists have had experience in off-license use of GnRH analogues in many settings. They can be used to prolong growing time in children born small for gestational age, children with inherited conditions such as congenital adrenal hyperplasia, and survivors of childhood cancers, where rapid, if not necessarily precocious puberty may jeopardise adult height. They've also been used to arrest delay puberty in young, distressed, severely learning disabled children who may be at the appropriate chronological age puberty, but don't have the emotional, psychological understanding of their physical changes or the physical ability to deal with them. If their use were to be restricted to only licensed conditions, many young and vulnerable individuals, both within and out with their gender service, would be deprived of a quality of life enhancing agent, and so on. And then she finally says it would go against our guiding principle of first do no harm. And so Dr. Albee, if you turn back to the beginning of her statement, is a consultant in paediatric endocrinology at the Leeds General Infirmary and an honorary senior lecturer for the University of Leeds. And you can see that from the beginning of her statement at 268. She's been a paediatrician for 30 years and a paediatric endocrinologist for 25 years. She's a member of the Royal College of Physicians and a fellow of the Royal College of Pediatrics and Child Health. She's an executive member of her professional body, the British Society for Pediatric Endocrinology and Diabetes. She's been a consultant in Leeds since 2000. And again, her evidence is almost as succinct and focused as Professor Butler's, and I'd invite you to read it in its totality. But in addition to the paragraph that I've just read out, If you have a look, please, at paragraph 13, she says she's seen Professor Butler's statements. She confirms that their approach is very similar to that approach at UCLH, and they work to the same service specification. And then she says this at the end of that paragraph: our sole purpose is to help very distressed, clear-minded young people achieve the happiness they seek in a safe, ethical and accountable manner. And then if I could invite your attention to paragraph 21, she deals a little bit with numbers. At the bottom of 275. So she looks at the period from the 1st of April 2018 to the 31st of March 2020, and says from the 145 people that signed the puberty blocker consent form at Leeds in those 2 years, 34 have subsequently signed consent for sex hormones. So there you have some real world data from a clinician who's using this treatment. And then at paragraph 28...
Well, just pausing there for a moment. It's one of the dangers of the random use of statistics in judicial review claims, if I may say so. So 145 signed the first consent form between April the 1st, 18 and the 31st of March 20. 34 have subsequently signed consent for CSH. What does that mean?
Well,
does it mean that 111 didn't, or had they not finished the treatment and it might come in a later period? That sort of question. In other words, what does it actually mean?
Well, my lord, what it gives you is some anecdotal evidence that it is not a one-way street.
Or does it?
Well, it doesn't.
Well, my lord, what you do have is that material combined with that which Professor Butler says about his perception of percentages.
Well, that's right. I mean, Professor Butler is clear that it's over 80% go on to CSH, and the legal significance of this. Don't take from my question that I'm necessarily accepting that there's much legal significance, but it's a growing concern I have in judicial review claims that the sprinkling around of statistics without the necessary explanation of what they really mean, and it can cause confusion.
Well, Lord, I 100% take that on board. What I was seeking to do by drawing your attention to this is that this is a clinician in practice, and as part of the picture that she paints consistently with that painted by Professor Butler is that in their clinical experience, it is not a uniform pathway in the way that the court described it, and I don't put my case any higher than that. It's not simply the case that you start puberty blockers, and I think the word inexorable was used.
Yes.
That's simply not the case.
I thought your point was rather than that most people starting on puberty blockers did not go on to cross-sex hormones. I thought the point was rather that it was wrong to say that the one was causative of the other.
Well, my lord, I think I'd probably say three things. One, certainly, constant conjunction is not causation. We know that from Hume and some other thinkers. Secondly, there is another explanation of the correlation, which is careful selection. The next point is that they are definitely clinically distinct, and we can see that they are clinically distinct because there are separate criteria for a referral for them. We know that those criteria deal with, for example, the time that needs to be spent on the first treatment before there is any consideration of the second treatment. And we know that there is a full and distinct process, both of assessment and then of consent taking. And thirdly, that numerically it's not simple. So that's how we put our case. Oh, my learned junior asked me to draw attention to page 17, paragraph 17, which sheds a bit more light on the data, to the extent that it can shed any light on order. I say I'm trying to keep you and my junior happy, and it may not be possible to do both.
Well, I think if one reads the balance of paragraph 21, there is an explanation of what's happening to the 111.
Exactly.
And nowhere does it suggest that one should assume that large numbers of them are not going to go on.
No.
Anyway, good. Well, thank you for paragraph 17. I'll have a look at that.
Then if I might invite your attention then to paragraph 28. And again, this is really a summative paragraph reflecting what went before in relation to consent taking. And she says, makes this point to which I've already adverted, the approach taken in consenting in the JIDS endocrinology clinic is one that can stand out as excellent clinical practice across the NHS. The approach to consent in this clinic is a multidisciplinary approach which takes place in the span of several weeks, if not months. It's also dynamic in nature, as at every appointment, each young person has the opportunity to withdraw from treatment. So it's not a simple momentary assessment. And then at 30, she deals with reversibility, and that leads up to the paragraph or in fact there are two 31s, but it leads up to the paragraph 31 which I read out. Again, I will draw your attention to that. And then if I can, before I get onto the law, because I'm aware that time is getting on, just deal with a few momentary matters in relation to changes in context since the last hearing. So the first of those we've touched upon is the stay that was opposed on the order. I've shown you that, and then you, just again for your note, it's in the core bundle at 283, its extension by the Court of Appeal. The next big thing that's happened is the judgment of Mrs. Justice Lieven in AB, and I've already mentioned that to you. If I can just make a few headline points in relation to that, again, perhaps without needing to take you through to this stage. At paragraph 33, Mrs. Justice Lieven specifically addressed the point that Ms. Bell and Mrs. A were not parties. So she was alive to that fact, but she, we say, rightly said, of course, the focus of the case was on the personal circumstances of that child. And it was a case concerned with the powers to consent. And then the other key points that I draw your attention to is that consistently with what I've just submitted, at paragraph 103 and thereafter, she made specific reference to the extensive regulatory framework that exists generally and specifically in relation to this work. She calls it layers of regulation. And she refers to NHS England and the service specification. She refers to the CAS review and its terms of reference. She refers to the Cqc. She refers to individual professional regulation. And so there's this constellation of regulation. And she specifically addresses the question at paragraph 115 and following. Is there a special category of treatment that requires an application to the court when all agree? And she answers that question, no, not here. Now, in terms of other changes in the light of the decision in Bell and the decision in AB, you'll be aware of my scattered argument there have been changes in the service specification by NHS England. And if I can summarise them. After the decision in Bell, my client established a process of multidisciplinary clinical those who were already on puberty blockers or who'd been assessed as ready to proceed but hadn't started treatment. And those reviews were focused on confirming that that referral was in their best interests, having regard to all the issues raised in VAL. And so essentially that assessment process, part of it was focused on whether the best interest criteria was fulfilled in relation to those patients. And a number of those, a significant number of those reviews have been completed, but in the meantime, of course, we had the judgment in AB. So in the light of that judgment, then NHS England announced a further safeguard, which is the establishment of a multi-professional independent review group. So another layer of review. And its purpose is to review the decision-making process in relation to patients under 16 who are being or have been referred for treatment at the Endocrine clinic. Work is being done to appoint individuals to that group, and subject to successful appointment, it's anticipated it will start its work next month.
Could you just, for my benefit at least, give me references for the documents?
So
Have we got them in the unagreed bundle?
My Lord,
Or perhaps they're in an
we
agreed
set
bundle.
it out in our skeleton argument where we've got to with NHS England. But it may be that I think that because of the time that the situation it just requires some updating. So certainly the first part of what I said is contained within our skeleton. Oh, it's in our supplementary skeleton. It's in our supplementary skeleton.
Thank you.
I think it might be at the end, the updating section.
So all the necessary references are there, are they?
My Lord, perhaps not the most up-to-date material I just said about appointment to the panel.
Oh, no, all
and
right.
so forth.
Just so that I have that, thank you.
It starts at page 15 of our supplementary skeleton.
And is it suggested that these changes are dependent upon the outcome of this appeal, or will go ahead anyway?
Well, certainly I don't represent NHS England, but with that caveat, my understanding is that they should remain in place. And certainly we can check that with NHS England. They were made an interested party, they're not represented. But we can certainly check that, my Lord. Certainly, as you would appreciate, one of the driving concerns in this appeal is the indication there should be applications to the court, because all the implications that has families, the NHS, and indeed for the court. And in that sense, the concerns parallel very closely those in Briggs picked up in Wye.
But it'd be surprising if they didn't carry on with all of these reviews and so on, given the findings of the Care Commissioner that it was an inadequate service.
My lady, it will be very surprised. I just must make sure that I check. But again, my lady, I would be very surprised. But we must just check that. I think another element as well, perhaps, is that is particularly important. We would say for this court to address are the elements in paragraph 138, and whether that's a proper way of dealing with consent taking, whether it's from a parent or from a child, and the extent to which such a list might be considered consistent with Gillett.
Yes. Well, that's what the appeal is strictly speaking about.
Exactly.
But will you be? I mean, I appreciate that both this decision and Mrs. Justice Lieven's decision in AB are both High Court decisions which don't bind us. But in your submission, where is the suggestion left that there should be applications to the court in the context of Mrs. Justice Lieven deciding, if I may say so, following my lady's view in this court and Lady Black's view in the Supreme Court, that if everybody is in agreement, i.e. the patient, the patient's parents and the doctors, clinical team, I should be more accurate, then there's no need to apply.
Well, my lord, there's certainly a real sense of confusion on
Quite.
the part of doctors, because the clinical position before Court Below in this case was identical to the clinical position in AB, in that it was always consensual decision making, and so that consensual decision making, albeit that the legal, what was relied on legally was the child's consent as opposed to the parent's consent. So that's the first uncertainty for doctors, particularly where, as you have seen, a great deal of the treatment is carried out by GPs, because otherwise children will have to travel across the country for their treatment, which is not good in a post-trial. The second issue, my lord, is this, that once that chink is opened up in the Gillick test, it may be that others will seek to expand it, and that's another reason why it's important, we say, particularly because Tavistock is concerned with the treatment of children and adolescents as a whole. It's not only concerned with the needs of children with gender dysphoria. And you can see that the history of litigation in this territory. The other important thing is this, as I say, this question of what is relevant and to be taken into account. And then finally, and I think this is particularly developed on behalf of Liberty, there are, of course, a group of children who seek treatment who don't have a parent. And it will be the position of those children who are looked after by local authorities. How might that be addressed? And those are the children who there is a concern might be required effectively, or there might be required there to be an application for in relation to them. And that would be unfair and unnecessary, again, when there is actually agreement. So I'll check over the short term whether I've...
That's a bit complicated, isn't it? Because that doesn't just depend necessarily, does it, on the clinical view and the child's giving competence, because you may have a local authority, a statutory parent, who feels that giving consent under Section 33 of the Children Act 1989 to puberty blockers for a child of, say, 13 is out with that which it's proper for them to give consent. So that there might be, we've got to be careful there, because there might be a different route whereby such a state of affairs ended up before a court.
Milady, certainly our position is that the important thing is for the court to appreciate that number one, parent isn't 100% the answer, so AB doesn't sort everything out for everyone. And secondly, that precisely the reason that Milady has given, that's a complicated territory. Again, there should be some respect given to the decisions which are being made on the ground, and again, a requirement that there has to be an application of every case is one which ought to be, is something that ought to be argued out, and there hasn't been any arguing of how that ought to be dealt with. But I think the core proposition is that relying on parental consent isn't a silver bullet, and it doesn't solve every problem. And that's indeed why we're here. You can imagine that no one makes an application for fulfilling and continues to pursue it without there being real reasons for it, and we submit that there are in this case.
But there is an interesting disparity, isn't there, between Gillick itself, where in that situation all those years ago, parental consent was normally lacking, whereas in this situation now, parental consent is normally present.
Well, my lord, we say that's really the peculiarity, that one compares this case with Gillick or indeed with Axon. Those cases were concerned with a tension between parent and child, whereas these cases are concerned with harmony between parent and child. And what's unique about them is that you have, and again, not just one doctor, but a team of clinicians, a family, and a child who all agree. And rhetorically, one asks them, why compel them to go through a court process? Imagine how intrusive and burdensome it is to all, and contrary, we say, to the public interest for a host of reasons. So, Lord, I'm aware of the time, and so what I propose to do now is turn to the law. You say that's core business. So, and I hope that I can take you through the law pretty conveniently, just sticking with the main bundle of authorities.
And we'll need page numbers as our tabs.
Yeah, so
We don't
my
have
learned
tabs.
junior has told me, I think, that if one is looking at the bundle electronically, one should add 6.
I had 2 actually in this bundle, but it's 6 in others, and 7 in others,
Oh.
and 3 in others.
Oh, I'm so
I'm
sorry.
coping, Ms. Morris, thank you.
I'm hoping a moment, because I've stuck with paragraph numbers where
Yes,
I can.
paragraph
apart from the more
numbers are
accurate ones,
fantastic.
so I'm hoping it won't be too awful.
Yep.
So, first plank, Family Law Reform Act 1969. It's the first authority, and you may have seen from our skeleton below that this momentous change in the law was the product of deliberations informed by the report of the Leahy Committee. And just for your reference, if you're interested, it's set out in REW, but also in our skeleton below, and you have that at page 603, paragraph 67 following, and it does say some nice things about long-haired rebels. But what it shows is that there was a great deal of care given, representatives of the BMA, and what Parliament decides is the consent of a minor who's attained the age of 16 years to any surgical, medical, or dental treatment in the absence of consent in constitutional trespass shall be effective as if he were of full age. So any surgical, medical, or dental treatment, no carve out, no exception, no if this, perhaps that, none of it. So next thing then is Gillick. We have Gillick, it's behind tab 5, it's at page 63. And I just draw your attention right at the outset to what's said by Lord Justice Parker in the Court of Appeal, because it perhaps has some interesting parallels in this case. Now, in the bundle it's page 72, and the internal pagination 121, and it's the paragraph by F, and it was this: it's clear that respectable and responsible people may hold different, strong and sincere views as to whether, and if so, in what circumstances, doctors should, on medical, social, moral, religious or ethical grounds, either 1, fail to inform a parent of a child under 16 who sought contraceptive advice, 2, provide contraceptive advice. This appeal, however, is concerned only with the legal position. And then if you turn on, please, to Lord Fraser, that starts at 162 of the internal pagination. And what Lord Fraser did was take the Family Law Reform Act as his starting point. You go on then to 169 of the internal pagination. The key part there starts at B. Seems to me verging on the absurd to suggest that a girl or boy aged 15 could not effectively consent, have a medical examination of some trivial injury to his body, or even to have a broken arm set. Of course, the consent of the parents should normally be asked, but they may not be immediately available, provided the patient, whether a boy or girl, is capable of understanding what is proposed and of expressing his or her own wishes, see no good reason for holding that he or she lacks the capacity to express them validly and effectively, and to authorise the medical man to make the examination or give the treatment which he advises. After all, a minor under the age of 16 can, for example, enter into a contract, and he goes on to deal with other matters that the Leahy Committee concern themselves with. And then between E and F, he says, I'm not disposed to hold now, for the first time, the that a girl aged 16, aged less than 16, lacks the power to give valid consent to contraceptive advice or treatment merely on account of her age. And then at the bottom of the page, there's no statutory provision which compels me to hold that a girl under the age of 16 lacks the legal capacity to consent to contraceptive advice, examination, treatment, provided that she has sufficient understanding and intelligence to know what they involve. And then if I can invite you please to turn on to 172. And then just after this, between C and D, it is a question of fact for the judge or jury to decide whether a particular child can give effective consent to contraceptive treatment. And then at 174, starting just between C and D, this is what he says a doctor will be thinking about. The doctor will, in my opinion, be justified in proceeding without the parent's consent or even knowledge, provided he's satisfied that the girl understands, can't persuade her to inform her parents, she's very likely to continue having sexual intercourse and so forth. So these are a list of factors for the doctor to think through, not a set of tests that a child must surmount in order to demonstrate competence. Then at internal pagination 176 we have Lord Scarman, and at B he acknowledges the fact that they are concerned with
Sorry, which page?
it's internal 176.
Thank you.
Yeah, of the bundle. Internal page 176, just before D, he acknowledges that they're concerned with a field of medicine unknown to our fathers but of immense consequence to our society. And he again acknowledged the novelty of the treatment at 182. That's internal 182 between G and H. 3 features have emerged in today's society which were not known to our predecessors: contraception, increasing independence of young people, the changed status of women.
So which letter on 182 was that?
Between G and H.
Oh yes, I see. Thank you.
And he again takes the Family Law Reform Act as his starting point at 183. And then I'd invite your attention to 184, the way that he articulates what he calls the fundamental principle in A and B. Nor has our law ever treated the child as other than a person with capacities and rights recognised by law. The principle of the law, as I shall endeavour to show, is that parental rights are derived from parental duty and exist only so long as they are needed for the protection of the person and property of the child. That principle has been subject to certain age limits set by statute, and then just before C, these limitations in no way undermine the principle of the law and should not be allowed to obscure it. And then I'd ask you to look at 186, starting before B. If the law should impose upon the process of growing up fixed limits where nature knows only a continuous process, the price would be artificiality and a lack of realism in an area where the law must be sensitive to human development and social change. If certainty be thought desirable, it is better that the rigid demarcations necessary to achieve it be laid down by legislation after a full consideration of all the relevant factors than by the courts, confined as they are by the forensic process to the evidence adduced by the parties and to whatever may properly fall within the judicial notice of judges. Unless and until Parliament should think fit to intervene, the courts should establish a principle flexible enough to enable justice to be achieved by its application to the particular circumstances proved by the evidence placed before them. And then the underlying principle of the law was exposed by Blackstone. It says this: the parental right yields to the child's right to make his own decisions when he reaches its sufficient understanding and intelligence to be capable of making up his own mind on the matter requiring decision. And then if you turn on please to 188. Just before B, the House must in my view be understood as having in that case accepted that, save where statute otherwise provides, a minor's capacity to make his or her own decision depends upon the minor having sufficient understanding and intelligence to make a decision and is not to be determined by reference to any judicially fixed age limit. And then if you turn on to 189, please. He says also, between A and B, it will be a question of fact whether a child seeking advice has sufficient understanding of what is involved to give a consent valid in law. And then at C, he says this: when applying these conclusions to contraceptive advice and treatment, it has to be borne in mind that there's much that has to be understood by a girl under age 16 if she's to have legal capacity. Not enough that she should understand the nature of the advice which is being given. She must also have a sufficient maturity to understand what's involved. There are moral and family questions, especially her relationship with her parents, long-term problems associated with the emotional impact of pregnancy and its termination, risk to health of sexual intercourse, risk which contraception may diminish but can't eliminate. Follows the doctor will have to satisfy himself that she's able to appraise these factors before he can safely proceed upon the basis that she has at law capacity to consent. But there, no declaration, no understand, retain, weigh in the balance, no prescription of the same character. And we say that is the correct approach. And also, if you turn on, please, to 191, even though, of course, the regulatory framework was less developed then, there is by law Starman's specific reliance upon it at B. It can
Sorry,
be said
191.
191 between B and D. It can be said by way of criticism of this view of the law that it will result in uncertainty and leave the law in the hands of doctors. The uncertainty is the price which has to be paid to keep the law in line with social experience, which is that many girls are fully able, so again a different presumption there, to make sensible decisions about many matters before they reach the age of 16. I accept that great responsibilities will lie on the medical profession. It is, however, a learned and highly trained profession, regulated by statute and governed by a strict ethical code, which is vigorously enforced. Abuse of the power to prescribe contraceptive treatment for girls under the age of 16 would render a doctor liable to severe professional penalty. The truth may well be that the rights of parents and children in this sensitive area are better protected by the professional standards of the medical profession and by a priori legal lines of division between capacity and lack of capacity to consent, since any general dividing line is sure to produce, in some cases, injustice, hardship, and injury to health. So, my lords, my lady, we say that all of those propositions bite precisely and deeply on the court in this case. And that bite should have been felt by the court below. And its failure to perceive it led it into error. So there are just two cases I'll invite the court's attention to, which consider get it a little further and provide us with some assistance. And they're cases indeed considered by Mrs. Justice Lieven in AB. And the first of those follows on at tab 6. It's in re R.
Bundle page number.
159.
Thank you.
It was concerned with the treatment of a mentally ill 15-year-old with antipsychotic medications. And if I'm, is it bundle number or internal pagination which is more convenient?
Doesn't matter to me.
put us on the spot. I prefer the internal page number
Oh.
because it then enables me out of court to look electronically. So
Well, that's what I have, my lord, so that's
Yes.
easy. So internal page 24.
So this is shortly after Gillick.
Yes. It's the speech of Lord Donaldson between A and B on page 24. Reflecting on Gillick, he says, it's fundamental to the speeches of the majority that the capacity to consent will vary from child to child and according to the treatment under consideration, depending upon the sufficiency of his or her intelligence and understanding of that treatment. And then if you turn on to the page 25 at H, just below a heading, Gillick competence. The House of Lords in that case was quite clearly considering the stage development of a normal child, and of course that's how he distinguishes position in that case of a mentally ill child. But he explains the character of the issue in the ordinary case at the top of 174 and internal 26. What's really being looked at is an assessment of mental and emotional age as contrasted with chronological age. But then he says obviously there's a further step in that case because of the mental illness. And indeed you see it at D. There you've got a child who he says is actually sectionable and no child there could be regarded as Gillick competence. That's how he distinguished the case. And then where he sets out his 4 propositions at the bottom of page 26 at paragraph 4, Gillick competence is a developmental concept. And then the next case in the bundle is in re W, 1992. Lord Donaldson again. And it's concerned with a Jehovah's Witness child refusing life-saving treatment.
Which tab is that on?
It's tab 7, my lord. And 181 page number, although I know that's maybe and perhaps in passing it's worth noticing at internal page 80, although it's at the very least over that Lord Donaldson accepts a proposition in relation to children, which is certainly accepted in relation to adults, at the bottom of 197. Although he personally says religious or other beliefs which bar medical treatment are irrational, that doesn't mean that if a minor holds them, they're necessarily not competent. So it's the same approach then he's taking in relation to adults, although it's not engaged here. And then if one turns on to 88, between D and E, it will normally be in the best interest of the child of sufficient age and understanding to make an informed decision that the court should respect its integrity as a human being and not lightly override its decision on such a personal matter as medical treatment. All the more so if that treatment is invasive. However, he acknowledges between F and G that a point will come if the child is seeking to refuse treatment in circumstances which will, in all probability, lead to the death of a child or severe permanent injury. So the threshold for court intervention is there set high. And then if one continues on the speech of Lord Justice Nolan, there he considers a speech given by Mr. Mumby QC, very much a long time ago was, and at 94. And then in response to the submissions that are made, he tries to identify more specifically than Lord Donaldson did where the threshold comes. Between A and B, he says, one is then to try and specify the grounds upon which it will be right for the court to intervene. I do not, for my part, find it particularly helpful to speak in terms of special, extraordinary cases as distinct from normal cases. He says he broadly accepts Mr. Mumby's third and fourth propositions, and we've got those on the preceding page, internal pagination 92. And essentially, what he is focused upon is the proposition that an individual who's reached the age of 18 is free to do as he wishes, but it's the duty of the court to ensure he survives to reach that age. Now, the next case is Axon. You have that behind tab 8, bundle page 212, in comparable territory to this, dealing with contraception, sexually transmitted diseases, and particularly abortion. And it was a decision of Mr. Justice Silver. And as we've already noted, a case where there's a tension between child's rights and parents' rights, which isn't present here. But it's worth bearing in mind, we submit what was said by that judge about the evidence that was put before him. Turn to 552, internal pagination. Paragraph 30 between F and G. Appropriate to mention at this stage there were very many witness statements produced by the parties, and together with the exhibits they filled 8 large ring binder files. Material in those files has been only of limited use to me because first, on many issues there's limited statistical evidence. Second, much of the evidence comes from countries such as the United States, in which the attitude to sexual matters and abortion is different from that in this country. Third, there's a dispute between certain of the experts which cannot be resolved satisfactorily without cross-examination. Finally, many of the issues which have to be determined are questions of law in which the views of experts don't assist. So there are perhaps parallels then with this case. And then sticking with the law, and if you go on please to paragraph 76, and that's internal page 566. He considers a judgment of Lord Justice Thorpe in Mayborn and Mayborn, and to reach the conclusion at paragraph 80 that in the light of the development of the law of the rights of children, by that point, which is 2006, we get the conclusion at paragraph 80. In the light of this change in the landscape of family matters, in which rights of children are becoming increasingly important, it would be ironic and indeed not acceptable now to retreat from the approach adopted in the Gillett case and to impose additional new duties on medical professionals to disclose information to parents of their younger patients. And then I'd also ask you to look at paragraph 86 of the judgment. The fact that he considered Gillett to be a rule without exception. So if you have a look at 86C, the speeches of Lord Fraser, Lord Scarman and Lord Bridge do not indicate or suggest that their conclusions depended in any way upon the nature of the treatment proposed, because the approach in their speeches was and is a general application to all forms of medical advice and treatment. Indeed, the approach of the majority was to consider in general terms reasons why parental knowledge or consent might be required for medical advice and treatment, and again in general terms when that parental knowledge or consent would no longer be required. And then he specifically addresses a submission that was made to him lower down the page. It's in italics between F and G, and then his answer. Mr. Havers attaches importance to the very complex issues that have to be resolved before any woman can decide whether she should have an abortion. The issue that now has to be resolved is whether these issues are so important and so difficult that a medical professional is under no obligation to keep confidential advice and treatment which she proposed to give in respect of abortion unless to do so would or might prejudice the young person's physical and mental health. And he says, no, there's nothing so special about abortion. However, individually or socially traumatic it's considered. And then he then adapts what he calls the Fraser Guidelines at 154. And again, no declaration, no reference to treatment other than the treatment with which the specific decision was concerned, and no indication that there should be an application to the court or any guidance of that character. And also no listing of what has to be understood, retained or weighed. Now, the next plank of the law, and I'm not going to ask you to turn it up, but just to note it, of course, is the Mental Capacity Act. And just perhaps a couple of points, though it's of course concerned with adults, there's a presumption of mental capacity, and it's displaced where A, there's some evidence of mental impairment, and B, it's demonstrated that the person is unable to understand, retain, and weigh information. And it's perhaps worth noting, alongside the other point I made about it saying there must be efforts made to assist development of capacity, it specifically prohibits a finding of incapacity on the basis of age or medical condition. So that's the way in which adults are treated. Now, a mental capacity case that was relied upon by the court below is the case of S, and we have that in the authorities bundle behind tab 12. And it's a decision of
Page.
Page 383. It's a decision of Mr. Justice Cobb, 2017, and it concerns a child deciding to release their child for adoption. And what Mr. Justice Cobb did was he said, well, I'm going to apply Gillick, but I think that the Mental Capacity Act principles are useful. In doing that, he said, I'm going to do what we do in Mental Capacity Act cases. I'm going to draw up a list of salient information. But the critical difference between S and our case is that the salient factors identified by Mr. Justice Cobb were legal factors. And so, of course, Mr. Justice Cobb was uniquely well placed to draw up such a list of salient factors as a judge. And that is a vital, we say, enormous distinction between this case and Mr. Justice Cobb's case, because the judges below were not in a similar position to draw up a list of salient factors. It appears that they were persuaded, relying on RES, to draw up that list, but we say that was wrong for a host of sophisticated legal reasons, but perhaps crucially, they simply weren't in a position to do so because they were lawyers and not doctors. I'm going to try and squeeze in at least one more authority, if I may.
Could you just help me? I'm looking. I'm trying to find precisely where the list is. It's 30.
It's 402 bundle and internal page 196.
Oh yes, paragraph
And it's
62.
62, little Roman 7, salient or sufficient information. And it says it's limited to the fundamental legal consequences.
Yes.
And of course, there's the one way of looking into this, if I remind you that, of course, it was never pleaded in this case on either side that the court draw up a list of factors to be weighed in the balance by a child. And if the court were to engage in such a project, we say it ought to be assisted by the evidence of clinicians who could guide the court. What the court can't do as lawyers is trespass into a territory which is not entirely its remit.
What was the substance of the list dealt with in argument?
It was never ventilated, my lord. So it wasn't the case that, as is sometimes the case with courts, the court goes away and reflects on submissions and thinks, well, X hasn't been addressed or Y hasn't been addressed. And can we hear more about that? And it was never tested in oral argument either. So what we did get before the hearing was a message from Mr. Justice Lewis saying, you know, I want people to address me on re-S. But certainly, I never understood that, and it was never put to me or anyone else that in re-S should lead the court, in our case, to draw up such a list of factors. And if it had been, our submission would have been, there can't be drawing up a list of factors to guide clinicians without hearing from clinicians on what that list of factors should be. So, I mean, if it were the right project for the court in relation to any medical treatment, say what is it that a patient must understand before they give consent, one would need to hear from the doctors, either from a particular professional body or from the GMC or the BMA, whatever one can, you know, they very commonly express their views to the court, but there was no such opportunity in this case because there was no warning.
Thank you.
So, my lord, shall I try and get through one more authority before the...
Yes.
so tab 13, my lord.
And again, a page number, so that'll be quite close.
405.
405. So this is, oh yes.
So this is Sir James Mundy after the last hearing, considering whether the court can override the refusal of life-saving treatment by a competent 15 and then 16-year-old. Disagrees with Mr. Justice Cobb, be that as it may, about whether one can import the MCA. I say that ultimately not very much turns on that. But I would draw the court's attention to the following paragraphs. Paragraph 24, at the bottom of internal page, no, I don't have it actually, bottom of bundle page 411.
Yeah.
The focus must be on the particular facts and circumstances of the individual case. For here, as so often, context is all. And then 26, particular context and circumstances are crucial in the case of medical or surgical treatment. And then paragraph 162, he reviews the cases of re-R and re-W, so the judgments of Lord Donaldson that we've just looked at, and says that they are still good law. And then his conclusion at 168, little Roman 1, determining whether or not a particular treatment is medically required is highly fact-specific. It cannot be subject to speculation or generalisation, certainly not in advance.
Is that a convenient moment? That was absolutely punctual, if I may say so. We will rise now and see you again at 2 o'clock.
All right.